Great. Well, it was an extraordinary term, and I want to start talking substance and begin with privacy, a favorite topic of mine, and I know of
You're
yours.
the world's expert.
No, hardly so. You wrote one of the great privacy concurrences of the year in this wonderful case involving, of all things...
I'm not sure there were a lot of privacy concurrences of the year. There might only have been one.
Well, there was a great privacy dissent, which was written by Justice Scalia, actually.
It was a great dissent.
That was the best. Well, let's just give a shout out to Justice Scalia right now.
It was an amazing dissent.
It was the most amazing privacy Fourth Amendment dissent of the entire year. This is the case involving, can the police take a DNA swab from a suspect on arrest and put it in a database? 5-4, the majority of the court says, yes, that's fine. And Justice Scalia, in a dissent that you joined, invokes the founders of the Fourth Amendment and said they would have been horrified by the idea of royal authorities intruding into the colonists' mouths.
What's the great idea? Something like opening their mouth for royal inspection.
That was it, yeah.
Is that the last line?
Beautiful. What, you joined that? What did you think of that?
Nobody else writes like him. He's extraordinary.
Well, you gave him a run for his money in this great concurrence, which was excellent. So the case is a dog sniff, and the question is, can the police bring a dog onto your front porch without consent and have it alert to drugs and then go in your house without a warrant? And Justice Scalia said no, because it's a trespass. Your porch is part of your private property. But you wrote a separate concurrence. First of all, you have this amazing way of seizing the audience's attention by speaking directly to us. And you said something like, imagine the dog comes onto your front porch. Would you think that was a trespass? Yes, you would. And would you think that was an invasion of your privacy? Yes, you would think that too, you said. You sort of grabbed our attention that way. Tell us what it was that you thought needed to be said in addition about why, in an electronic age, privacy has to be protected not just by property rights, but also by expectations of privacy.
Yeah, I mean, it's interesting you said in an electronic age. In a way, this was a very old school kind of case. You know, it was about dog sniffing, which is a kind of law enforcement technique that has existed for many decades. But at the same time, it's really quite connected to a lot of the newer Fourth Amendment issues that we have started to deal with and that we're going to continue to be dealing with. This is going to be, I think, a growth industry for the court. You know, the next decade, I think we're going to have many of these cases. And there was a lot of similarity between this case about the dog coming up to your front porch and sniffing and a case that we had last year, which was about GPS, the use of GPS surveillance. And there, the police officer had put like a card on a car and then had been able to track the movements of that car every minute of every day for weeks and weeks and weeks. And the question was very much the same, was that could the police do that without any kind of warrant, without even probable cause? And in both cases, Justice Scalia wrote and talked about property interests. And even as to the car, said when you put something on a car, it's a form of trespass, even though most of us wouldn't consider it as such. And the purpose of my concurrence really was to say, you know, property is part of what, invasion of property is part of what makes for a Fourth Amendment violation. It's not only about privacy, it is about expectations of privacy more generally, so that it wouldn't matter, for example, whether you actually put something on the car and committed a formal trespass, or whether you could do the exact same thing with techniques that didn't involve a trespass on property. And this is not a new concept. You know, this goes back to Louis Brandeis, who looked at wiretapping and said, look at this, you can do wiretapping without invading anybody's property interests, but you get the same thing, and you invade privacy, and you invade, you know, what makes the prerogatives of a person over their own stuff in the same way.